address them later on. And I will also add my email to the chat box in case you run into any technical difficulties. And then feel free to reach out to me with any other concerns you have as well. Today's presentation is on inappropriate behavior and the inclusive workplace. But before I introduce the speaker, I would like to announce that this month KUTC will be hosting our two-part transit manager training. The first part is coming up on the 7th of February, and more information and registration about that are available on our learning management system. And I'll add a link to that in the chat after I'm finished with this too. So now I'll introduce today's speaker. Today we have Ruth Glover, the Executive Director of the Kansas Human Rights Commission. And Ruth joined the Kansas Human Rights Commission in 2004 and has been the Executive Director since 2014. Ruth is also a KU mom. Her daughter started working on her master's in communications at KU last fall. And today Ruth will be discussing with us inappropriate behavior and the inclusive workplace. I'll go ahead and turn it over to Ruth.
Well, thank you, Peyton. I appreciate the opportunity to spend some time with you today, and I hope the presentation is informational for you. If you have any questions, feel free to go ahead and unmute and ask your question or type it in the chat box. And if I miss anything, just let me know. I've got like 3 screens going on here, so sometimes it's a little, gotta have some help to keep track of everything. So as Peyton mentioned, we're going to be visiting about inappropriate behavior and the inclusive workplace. This is basically our harassment presentation. So we're going to go over what an inclusive workplace is, and then we're going to touch on civil rights laws that prohibit discrimination, harassment, and also sexual harassment. And then we're also going to visit about other inappropriate behavior in the workplace. It may not rise to the level of harassment, but it's often unprofessional or toxic or uncivil. It often is disrespectful towards other people. So what is an inclusive workplace? It's one that welcomes all individuals, treats them with dignity, and respects their differences. Now in here, it doesn't say anything at all about liking your coworkers or liking your supervisors, but everyone should be treated in a professional manner in the workplace. It also doesn't say anything about that you have to agree with each other's religious beliefs, political opinions, or lifestyle choices, but everyone should be treated with courtesy and respect in the workplace. So why is inclusiveness important? Well, 2 heads are better than 1. Here at the Kansas Human Rights Commission, we're just a little bitty agency. And so I have learned that whenever we have something new to implement or some difficult question to answer, that we often have a better solution if I involve more people in the process. And the reason behind that is different people are going to have other individuals are going to have different skills than what I might have, a different background than what I might have. They might have expertise in a specific step of our process, something of that nature. And so they're going to bring more skills and knowledge to that solution. And so we're going to have a better product either to offer to the people that we serve or to our employees. Also, it's been shown that organizations that reflect their customer base and reflect their community are more economically profitable than those that don't. And I know being with transportation organizations, you may not be about making money, but we all get judged on how effectively and efficiently we provide our services. Also, it's important to maintain a good reputation in the community. If someone feels like they have been mistreated in the workplace, are they going to keep that to themselves? No, they're going to go home and tell their friends, their family, anyone who will listen, basically. And so if that happens over and over again, then that organization is going to have a damaged image, a damaged reputation in the community. Also, many organizations want to be a good partner in society. So sometimes if you read their websites, you'll see that they're embracing diversity or equity or inclusion, or they're embracing equal employment opportunity. And then lastly, discrimination and harassment are against the law. So what happens when someone feels like they've been mistreated in the workplace? Well, first of all, they can file complaints internally with your organization. They can also file complaints with us, the Kansas Human Rights Commission, or they can file complaints with our federal partner, the U.S. Equal Employment Opportunity Commission. Now, just to check how active the EEOC was, I had checked their website, and in 1 month period, they had either sued or settled with 29 different employers. And on the right side of the screen, you'll see the settlement amounts. I think the highest amount on the screen is $2.5 million. The lowest amount is $25,000, but even $25,000, that's a lot of money coming out of an organization, all because someone wasn't treated in the appropriate manner. Also, once an individual files a complaint, either with us, the Kansas Human Rights Commission, or with the Equal Employment Opportunity Commission, they are on the path where they can file a civil lawsuit on their own, even if we do not find evidence to support their allegations. Also, depending upon what the behavior is, criminal charges might be appropriate in some cases. And there's also other hidden consequences. There's poor morale. If people feel like they're not welcomed in the workplace, if they feel like they've been mistreated in the workplace, then they don't want to be in the workplace. They're going to have more sick leave. They're going to be tardy to work. And even when they are at work, they're going to be less productive than the people who do feel like they're welcomed in the workplace. There may be increased legal fees associated with complaints that are filed with the Kansas Human Rights Commission or the EEOC or with civil lawsuits. There's a hidden cost where it takes time for supervisors and human resources to investigate any type of complaint also. And I know I talked to one human resource director. She had talked about that there were increased insurance costs, that they had to settle several cases, and because of that, their insurance costs increased. And so they were spending money on insurance premiums that really they would have rather spent in another way that benefited the people that they served or their employees. And then lastly, there's public embarrassment. If you think about the most recent case, I guess the big case has been Robert Sarver from the Phoenix Suns and Phoenix Mercury. The NBA fined him $10 million after an investigation for workplace misconduct and organizational deficiencies. And he was found to have used racially insensitive language, unequal treatment of female employees, and sex-related statements and conduct, and also bullying of employees. And I think he's put both the Phoenix Suns and the Phoenix Mercury up for sale. I haven't kept track of what's happening with that. If you think of other incidents, there was Harvey Weinstein. He's been run out of his own production company. He's been convicted of different criminal charges, both in New York and California. If you remember Matt Lauer, he was let go from the Today Show within 48 hours of being accused of sexual harassment. And Roseanne Barr also lost her TV show, all because she was making inappropriate racial tweets about an individual. So unfortunately, there's lots of examples. Now, this is our Kansas law, the Kansas Act Against Discrimination. Kansas was the 12th state to have an anti-discrimination law. Our mission is to prevent and eliminate discrimination in employment, housing, and public accommodations. We are a neutral investigative agency, and we work to achieve our mission through two different points. First of all, we receive, investigate, and resolve complaints of discrimination, and then we do education and outreach in the hopes that if people can learn what discrimination and harassment are, then it won't occur in the future. Now, the Kansas Act Against Discrimination prohibits discrimination in employment, housing, and public accommodations. So that means that we protect people where they work, where they live, and where they consume goods and services that are offered to the public. Now, a lot of times people think of anti-discrimination law as only protecting minorities or only protecting women, but in reality, the law protects everyone. So for race, it protects every race. For religion, it protects people who have a religion. It protects people who don't have a religion. And it also protects people who have different viewpoints of the same religion. So sometimes we'll receive complaints from, say, more conservative Christians who feel like more liberal Christians have discriminated against them or harassed them, or the other way around. We'll receive a complaint from a more liberal Christian who feels like maybe a more conservative Christian has discriminated against them or harassed them. Now, color is the color of your skin. So we do receive these complaints most often from people of color based on the lightness or the darkness of their skin tone, but color also includes skin discoloration. So if someone has, say, like a port wine stain or a rosacea, and they feel like they've been discriminated against or harassed because of that skin discoloration, then they can file a complaint underneath the category of color. National origin is based on the country where you were born in. So if someone, and most often we do receive these complaints from people who have been born outside the United States, but have come to live and work in Kansas, and now they feel like they're being discriminated against or harassed because they came from another country. But as the workplace has become more diverse, we've received more complaints where people were born here in the United States, but they have coworkers or supervisors who were born elsewhere, and they feel like they're getting discriminated against or harassed because of that difference. Ancestry is your family heritage. So a lot of times in these situations, our forefathers, our foremothers, generations back, have come to the United States from a different country. And now that individual feels like they're being discriminated against or harassed because of that family background, that family heritage. Sex for us includes gender, so male or female. Sex for us also includes pregnancy discrimination. And sex for us also includes gender identity and sexual orientation. In June of 2020, there was a U.S. Supreme Court decision called Bostock versus Clayton County. And in that decision, the U.S. Supreme Court ruled that at the federal level for the Equal Employment Opportunity Commission, that sex included sexual orientation and gender identity. Our commission board concurred with that decision. And so now the Kansas Human Rights Commission can accept complaints underneath the category of sex that include LGBTQ+ and all derivatives of sex. Disability actually has three parts to it. The first part is that you actually do have a disability. The second part is a record of a disability. So a lot of times underneath this, we see where individuals have had time off underneath the Family and Medical Leave Act or workers' comp, because that shows that they've had some type of serious illness or injury, and there are records of that, either electronic or paper records. And they feel like they've been discriminated against because of that history of having some type of serious health condition or injury. And then the third part is being regarded as being disabled. So underneath this category, the individual doesn't have a disability, but other people think of that person as being disabled. So a lot of times we see that where individuals have had that time off underneath the Family and Medical Leave Act or underneath workers' comp. They say that they've been released to come to work, that they can perform the essential functions of the job, but the employer never schedules them to come back to work. Or if they do come back to work, they get these disparaging comments, kind of like, well, you can't keep up like you used to. When are you going to take more time off? You know, different things like that. Age is 40 and over. Family status, and that's really for housing complaints. That's when you have children or grandchildren underneath the age of 18 living with you. And then there's genetic screening and testing. And this is our equivalent to the Genetic Information Non-Discrimination Act at the federal level. And underneath GINA, the Genetic Information Non-Discrimination Act, that prohibits employers from asking applicants or employees about their family health history, requiring them to divulge that information, or purchasing that information from a third party. And the reason behind that is all of us probably in our family tree have had some relatives who have had some type of condition that might be genetic in nature. You know, if you think about cancer, diabetes, Parkinson's, any of that might have a genetic link. But just because we've had a family member who has had something, an illness that's genetic in nature, doesn't mean that we're actually going to ever develop that. So our employer should be judging us based on our work performance today, not what our health condition may or may not be, 10, 20, 30, 40 years down the road. The Kansas Act Against Discrimination also prohibits retaliation for outwardly opposing discrimination. So to us, outwardly opposing discrimination means that someone has complained internally about discrimination, filed a complaint with us or the Equal Employment Opportunity Commission or another entity, or participated in an investigation or a lawsuit, either this person who is complaining or who has acted as a witness in an investigation or lawsuit. Or if someone has asked for an accommodation for a disability, or if they've asked for an accommodation for a religious practice, any of that could be covered by retaliation. Now, I was mentioning that a lot of times people think that discrimination law only protects minorities or just women, but really the law protects everyone. So in fiscal year 2021, these were all the reasons that individuals filed complaints of discrimination with us. So let's take a closer look. Underneath race, we had 253 Black or African American individuals who felt like they were being discriminated against or harassed because of their race. We also had 25 white people who filed complaints who felt like they were being discriminated against or harassed because they're Caucasian. And for sex, we had 259 women file complaints against saying that they were discriminated against or harassed because they're female. But we also had 79 men who felt like they were being discriminated against or harassed because they were male. So the law covers everybody. Now, it's illegal to harass an applicant or an employee because of any of the protected classes. So race, color, religion, sex, including pregnancy, LGBTQ+, and all derivatives of sex, an individual's ancestry, which is their family heritage, their national origin, being the age of 40 or over, disability, or genetic information. It's also illegal to harass someone because they've complained about discrimination, file a charge of discrimination, or participate in an employment discrimination investigation or lawsuit. It's also illegal to harass someone because they've requested an accommodation for a disability or for a religious practice. Now, in Kansas, in fiscal year 2021, 53% of the complaints that were filed with us alleged some type of harassment. So over half of the complaints that were filed with us alleged some type of harassment. And I know the Equal Employment Opportunity Commission has long felt that harassment is an important issue in the workplace and an important issue in society. So these are the reasons that individuals filed harassment complaints with us in fiscal year 2021. We had the number one reason was sex harassment. Excuse me. There were 188 women who filed complaints of harassment with us, sex harassment with us. There were also 54 men, and there were 2 based on sexual orientation. Now, there are 2 types of sex harassment. The first is gender harassment. That's when there's derogatory remarks, put downs, criticisms because of someone's gender. So, a lot of times in the workplace, we hear comments kind of like, well, men are always that way, or women are always this way. And when you hear comments like that, it never ends up being a positive comment. It always ends up being some type of dig or put down based on that person's gender. And so that would be an example of gender harassment. If you think of dumb blonde jokes, who's the dumb blonde? The dumb blonde is usually a woman. So that would be another example of gender harassment. Now, if the behavior becomes sexual in nature, then that becomes sexual harassment. The number 2 reason for filing a harassment complaint with us was race. The number 3 reason was disability. Then it dropped off to age. Then it dropped off to color. Then it dropped off to national origin and ancestry. And then it dropped off to religion. So the law does not prohibit simple teasing, offhand comments, or isolated incidents that are not very serious. The behavior becomes illegal if it is so frequent or severe that it creates a hostile or offensive work environment, or if it results in an adverse employment decision, such as the victim being fired or demoted. Now, harasser can basically be anyone that you are encountering as you're carrying out your official work duty. So a harasser can be a supervisor in another area, a coworker, and also a harasser can be someone that is not an employee with your organization, but someone that you're encountering as you're carrying out your official work duties, a client, a customer, or a vendor. And we call that third-party harassment. Kind of the classic example of a third-party harassment situation is a waiter or waitress, and they have a customer who says something inappropriate to them or touches them inappropriately. There was a survey on alleged harassers, and 60% were peers or coworkers, 36% were managers or supervisors, 9% were clients, 8% were senior management, 5% were vendors, and 3% were direct reports or supervisees. If you add those numbers up, it ends up being more than 100%. So I don't know if there was more than one alleged harassment situation or if there was more than one alleged harasser. A lot of times in our investigations, we find out that maybe people team up. So there might be a couple of alleged harassers who target a person. So it could be like a supervisor and a coworker who target someone. Now, harassment outside the workplace may also be illegal if there's a link to the workplace. So a lot of times we receive complaints where people are carrying out their duties outside their main location. So we get a lot of complaints when people are traveling together, like they're traveling to meetings together, they're driving routes together, they're making deliveries together, and someone makes a comment and it crosses the line. We also get a lot of complaints involving social functions outside the workplace. So if you think about holiday parties or a summer softball game, you know, a lot of times in those social situations, we're going to act differently than what we do in the workplace. And so sometimes people will say things or touch someone or do something that goes beyond the appropriate level. Also, I was listening to a webinar not too long ago, and there was an attorney who was talking about there are no more off hours when it comes to harassment. You know, these days we have instant access to everyone else. We have text messaging, we have email, we have social media. So we have instant communication with other people. And so those can be also tools of harassment or means of harassment too. Now, a victim can also be a bystander witnessing harassing behavior by others. So on this slide, we have this group of red, blue, and green and purple people, and they're all having a conversation. And if that conversation is all consensual with them, but if that conversation becomes based on a protected class, based on race, based on national origin, based on race, anyone outside that group can file a complaint. So for example, we had a complaint that involved a restaurant, and the kitchen staff were making derogatory remarks about the African-American customers who came in, and they were using the N-word all about it. And well, there was an African-American employee who could overhear these conversations. And so he complained to the owner, nothing improved. And so he ended up filing a complaint with us, and we found that he was a victim of discrimination because he was a bystander witnessing harassing behavior by others. Both the Kansas Human Rights Commission and the EEOC can accept complaints of aggrieved on behalf of. So in these complaints, the individual who is filing the complaint is not the actual victim of the discrimination, but they say that they are aware of discriminatory actions towards others. So we had a situation where there was an HR manager who was supposed to hire 2 people to work in a warehouse, and he ended up hiring 2 women to work in the warehouse, and they were well qualified to work in a warehouse. They knew about, you know, driving forklifts and loading and unloading trucks and things like that, and they had experience in those areas. And so he hired these 2 women. He texted higher ups at the company and said that he had hired 2 women. And he got a text message back that said, "We don't want women in the warehouse, get rid of them." So he knew that was illegal, but he went ahead and contacted these women and said that there had been a misunderstanding in quote marks. And so he ended up filing a complaint with us saying that he was aggrieved on behalf of these 2 women. He was not the victim of the discrimination, but he knew that these 2 women were victims of the discrimination. And he kept those text messages and supplied those as evidence as part of his complaint. He also told the 2 women about what had happened, and they filed complaints. And so we ended up having 3 probable cause cases because this one person said he was aggrieved on behalf of these 2 women. Now, when we evaluate a harassment complaint, we are going to look to see whether or not the situation is related to employment. But even things that occur outside the workplace can still be related to employment if the interactions are with coworkers or supervisors, someone who is linked to the workplace. And even things that occur after hours can still have that link to employment. We're also going to take a look at how the victim views the behavior. Was the behavior unwelcome to them? Do they find the behavior offensive? Did they ever initiate any of the behavior, or is it always the alleged harasser who initiates the behavior? We're also not going to look at the alleged harasser's intent. So it doesn't matter what the alleged harasser says, if they say that they're kidding around or just having fun or they didn't mean anything by it. We're going to look at the impact on the alleged victim. We're also going to take a look at how severe the behavior is. So how bad is the behavior? Is it sending somebody text messages? Is it making comments to them in person? Is it touching somebody? Is it touching people in their private parts? Or is it even worse than that? Now, we're also going to take a look at how pervasive the behavior is. So how often has that behavior occurred? Did it happen just once, or is it happening all the time? Now, the standard is that the behavior doesn't have to be severe and pervasive. It can be severe or pervasive. So if the behavior is bad enough, it only has to happen once or twice in order for us to find that probable cause that harassment has occurred. Or if it's low-level behavior like text messages or emails, if it's occurring all the time, then we can still find that harassment has occurred. Now, the behavior has to be based on a protected class. So derogatory comments about somebody's race or using racial slurs or, in association with somebody, derogatory comments about somebody's gender or put downs about somebody's gender, criticisms about somebody's religion, inappropriate nicknames for somebody's disability or age. So it all has to link back to a protected class. And then it has to create an intimidating, hostile, abusive work environment. And the standard that we're using here is a reasonable person in the victim's shoes using common sense and socially accepted moral standards. Now, this is the criteria that the Kansas Human Rights Commission or the Equal Employment Opportunity Commission is going to use to evaluate a harassment complaint. But a lot of times, employers will have some type of internal policy, an ethics policy, or a workplace conduct policy, some type of standards of conduct policy. So if there's some type of complaint that's filed with the internal organization, with the employer, they don't necessarily have to conclude that it's harassment. They can conclude that the behavior, whatever it is unprofessional or disrespectful or toxic, uncivil, inappropriate in the workplace. So they can take action based on their other internal policies, whether that's workplace conduct, professional conduct, standards of conduct, anything of that nature. So for sexual harassment, there's two types of sexual harassment. The first is hostile work environment, and we just covered that. There's also quid pro quo sexual harassment, and that means this for that. And it occurs when submission to unwelcome sexual conduct is made as a condition of employment or employment decisions. And in these situations, someone who has power over an applicant or an employee, a manager, a supervisor, or someone else in a position of authority, threatens an employee or applicant with some type of negative consequence or promises a benefit, and that applicant or employee feels like they have to tolerate unwanted sexual advances in order to avoid the negative consequence or in order to gain the positive. So we had a situation where there was a company going through layoffs, and they had 3 receptionists, and it was well known they were going to lay off some of the receptionists. So you would think they would keep on the receptionists with the longest seniority, the most seniority, but that's not what happened. The owner of the company went to the receptionist who had just been most recently hired and basically said, if you engage in an affair with me, then I'll keep you on and I'll lay off the other 2 receptionists. Well, the lady needed her job, so she accepted this proposal, and the 2 receptionists with more seniority were laid off. And then after a couple months, the receptionist who was retained ended up filing a complaint with us, and we found probable cause that there was quid pro quo sexual harassment, that she felt like she had to tolerate these unwanted sexual advances in order to avoid the negative of being laid off. We also had a situation where there was an individual who had applied for a job. She didn't get the job that she applied for, but the hiring manager started texting her and basically said, if you go out on dates with me, I'll make sure you get the next job that comes up. So she declined his advances, and he continued to text her, and she continued to decline his advances, and she ended up filing a complaint with us. We notified the employer about the complaint. They did their own internal investigation, and they found these text messages because, of course, he used his work cell phone to send these text messages. And they ended up firing the hiring manager because they felt he was engaging in quid pro quo sexual harassment, that he was making this applicant feel like she would not be hired unless she tolerated his unwanted sexual advances. Now, favoritism due to sexual favors. This is when one employee is rewarded in the workplace, promoted, given better work assignments or larger pay raises for cooperative sexual behavior at the expense of other non-favored employees. So in this situation, we have this romantic couple in the background. It's consensual and there's no rules against romance in the workplace with this employer. But if one member of that couple becomes like a boss's pet, someone who is favored over others, then anyone outside that relationship can file a complaint. So if someone gets to come in late, gets to take long lunch hours, gets to go on the fun convention trip that nobody else gets to go on, just because they're in a relationship with a manager or supervisor, then anyone outside that relationship can file a complaint. So the moral of that story is if there is some type of reward in the workplace, it should be based on performance at work, not because of a personal relationship with a manager or a supervisor. Now, same-sex harassment and same-sex sexual harassment. This occurs when an individual does not consider another person to meet the stereotype of that gender. So a woman isn't considered feminine enough, or a man isn't considered masculine enough. This goes back to a 1989 U.S. Supreme Court ruling that involved Ann Hopkins. She had applied to become a partner in the accounting firm that she worked for, and she did excellent work. There was no question about her work. But the people who were considering applicants for the promotion considered Ann to have male traits, in that she was overbearing, aggressive, dominant, and foul-mouthed. And so she was told that she needed to walk, talk, and dress more femininely, wear makeup and jewelry, and have her hair styled. So they weren't judging her whether or not she could do a good job. They were judging her on whether or not she met their stereotype of what a woman should be. Now, for the guys, there was a construction company in Louisiana, and there was a rough iron construction worker named Carrie. And Carrie's boss did not think Carrie was macho enough, man enough, to be a rough iron construction worker. He didn't like Carrie's name. He thought Carrie was a girl's name, and so he would tease Carrie about having a girl's name and calling princess and different things like that. And then Carrie was a smaller built guy, so again, his supervisor would tease him about being a girl and different things like that. Carrie complained to higher ups at the company. Nothing improved. He ended up filing a complaint with the U.S. Equal Employment Opportunity Commission. The EEOC took the company to work, and then the company ended up paying Carrie $125,000, all because he wasn't treated in the appropriate manner in the workplace. Now, these are samples of harassment, or tools of harassment. Some people might call them tools of harassment. Jokes, slurs, graffiti, offensive or derogatory comments based on any of the protected classes. So based on somebody's race, somebody's religion, somebody's age, somebody's disability, anything of that nature. We also get a lot of complaints involving verbal or physical contact, like blocking movements, pats, pinching, hugs, rubbing people, shoulder rubs, neck rubs, things of that nature. And for the huggers out there, you have to be careful that behavior does not cross a line. And, some people are naturally huggers and some people are not. So if you are a hugger, on the safe side, no hugging in the workplace. But if you are a hugger, then you need to make sure that the person who is receiving that hug is actually okay with it. Teasing, spreading rumor, telling tales, cat calls, whistle, any of those things should not be in the workplace. Nonverbal behaviors like staring, looking people up and down, suggestive looks, again, that doesn't belong in the workplace. We used to get complaints about pinup calendars and posters and things like that. But most of the complaints that we receive now involve some type of in-person conduct or some type of electronic communication, whether that's text messages, emails, some type of messaging through social media. I bet if you look at our files, probably 80–90% of our files have copies of text messages in them. So it's inappropriate to send inappropriate emails or links to inappropriate websites. I talked to a lady not too long ago, and she said that when she calls in sick, her supervisor calls back and leaves derogatory comments about her disability on the voicemail. So I was telling her that she needed to preserve those voicemails so that she could get them to her investigator. I was reading complaints not too long ago, and we received a complaint where a man says that he has a female coworker who likes to take like semi-nude pictures of herself, and then she shares those pictures with her coworkers. And so he felt like he was being sexually harassed because she was sharing those types of pictures with him. We do get complaints sometimes involving social media, especially the instant messaging function in social media. We had a case where there were 7 women who felt like their supervisor was making racial stereotypes about them, about what they would wear, what they would eat, different things of that nature. They ended up complaining to the organization and filing complaints with us. So we had 7 complaints filed against this one organization. And then when the supervisor found out that these individuals had filed complaints, she went out to Facebook, used the N-word, and listed all their names. And so then we ended up having 7 complaints of retaliation. So altogether, we had 14 complaints filed against an organization, all because of a supervisor's actions. Now, if you are harassed, it's best to tell the person to stop. Telling the person to stop can just be as simple as saying, you know, I don't like these jokes or comments or behavior. Please don't do that around me again. It's not required by law that you tell the person to stop. And we can understand that not everybody is going to have the gumption to tell the person to stop. But it is important that you advise management of the alleged harassment and to follow your organization's policies and procedures for reporting any type of harassment. We can't always hold the employer responsible for any type of alleged bad behavior if they didn't know about the bad behavior and have an opportunity to look into the situation and put a stop to it. Also, it's important to keep records. If in order for us to find probable cause, we have to have evidence of some type of harassment. So if there are notes left on desks, notes left on markers, if there are text messages, if there are voicemails that tie to harassment, then that helps support your complaint either internally or if a complaint is filed with us or with the EEOC. And I know a lot of times when we ask people, supply us those text messages or supply us the voicemails or whatever, they'll say they deleted them. And we can understand that because nobody wants to keep things that are hurtful to them. But on the other hand, like I said, in order for us to find probable cause, we have to have evidence to support the allegations. Now, since the Me Too movement, there's been an increased emphasis on bystanders speaking up when they witness some type of harassing behavior. If you see something, then say something. I listened to a presentation not too long ago. I guess I read an article from the EEOC, and it was saying that they think that 90% of the people who are victims of harassment never actually complain. So bystanders can be an important tool, an important asset in addressing harassment in the workplace. So advise management of any harassment and follow your organization's policies and procedures for reporting any type of harassment. Now, if you're a supervisor or human resources, it's important that you set an example. Sometimes when we ask people, well, did you report the harassment to your supervisor? They'll say, well, no, my supervisor acts just as bad as my alleged harasser. So it's important that as supervisors or human resource representatives, that you set an example, that you're setting that tone of what a professional, courteous, respectful workplace is. And then if other individuals deviate from that example, then it'll be known that that's not acceptable behavior in your organization. Also, know your organization's anti-harassment policy and complaint process. And it's not like you need to know it word for word, but just know where to find it if you have a question or if you think you might need it. Also, if you see harassing behavior in the act, put a stop to it and have zero tolerance for teasing or jokes based on any of the protected classes, even if the alleged victim does not seem to mind. Once a supervisor, particularly a supervisor who has the ability to hire and fire, becomes aware of harassing behavior, what the supervisor does or doesn't do becomes binding on the employer. So if a supervisor knows about harassing behavior but doesn't report that on or doesn't take action to stop the bad behavior, we can still hold that employer responsible, even if the supervisor never reports it on. And a lot of times we do receive complaints from people who have left an organization and they'll allege that their supervisor knew about the bad behavior and just never put a stop to it. And then we can still hold the employer responsible for that. If you receive a complaint or if you have a concern, then work together with your human resources or legals to address that situation. And like I said, supervisors have a duty to act on complaints, and then supervisors have a duty to protect the employee from the bad behavior. And by protecting the employee from the bad behavior, then they're also protecting the organization. And don't retaliate against someone for complaining or for participating in some type of investigation. This is a scenario on race harassment. Jonathan and Richie, well, first of all, are there any questions before we go on? Okay. This scenario is on race harassment. Jonathan and Richie work together. Richie has seniority over Jonathan. Jonathan's African American and Richie is Caucasian. Richie subjects Jonathan to a broad range of offensive behavior. He uses the N-word. There's a lot of inappropriate touching. There's a lot of shoving involved. And then Richie is taunting Jonathan about his sister and his mother also. And there are jokes, telephone calls, telephone conversations, voicemails, and text messages. And Jonathan never initiates the behavior. It's always Richie that initiates the behavior. So let's evaluate this. First of all, it's related to employment because Jonathan and Richie are co-workers together. Even things that occur outside normal work hours still have that link to employment because they're co-workers together. Now, the behavior is unwelcome to Jonathan. He never initiates the behavior. He finds it offensive. Richie says he's just kidding around, but that doesn't really matter. We're going to evaluate the impact on Jonathan, the victim, and we're going to set aside Richie's intent. So it doesn't matter if Richie says he's just kidding around or doesn't mean anything by it. The behavior is severe, particularly with the use of the N-word and with the physical touching involved, with the shoving involved. And also the behavior is pervasive. There are like thousands of text messages and thousands of voicemails and phone calls. It's happening all day long, every day. Now, the behavior is based on a prohibited nature. With the use of the N-word, that becomes based on race. And also, Richie doesn't consider Jonathan to be masculine enough to carry out the job that he has. So that would be same-sex harassment. And I would think a reasonable person would say that it creates an intimidating, hostile, abusive work environment. So this is the case of Jonathan Martin and Richie Incognito from the Miami Dolphins. This is an older case, but it's got a lot of good points to it. So we've kept it in our training lineup. Jonathan Martin left the Miami Dolphins because of the alleged harassment by Richie Incognito and two other offensive linemen. The Miami Dolphins asked the NFL to investigate, and the NFL contracted with a law firm. They wanted an impartial investigation, and whatever the results of the investigation were, they wanted them to be accepted with credibility. So the report concluded that 3 starters on the Dolphins offensive line engaged in a pattern of harassment against Jonathan Martin, another young Dolphins offensive lineman, and assistant trainer who was Asian. And the report cited racial slurs, racial derogatory language, name calling, and improper physical touching. Now, the report concluded that they did not intend to drive Martin from the team. But remember, we're going to look at the alleged impact on the victim, and it doesn't really matter what the alleged harasser's intent is. Now, a few months after the NFL's report came out, the Miami Dolphins ended up firing an offensive line coach and a trainer. These were the supervisors in this work situation. And so they were responsible for protecting the employees from the bad behavior. And by protecting the employees from the bad behavior, then they also protected the organization. One actually participated in harassing, and the other one knew about the harassment but didn't do anything to put a stop to it or to report it on. And because they didn't live up to their responsibilities of protecting the employees and protecting the organization, they got fired. This is a case on sexual harassment. Bob's the head of the organization, and Bob likes to ask subordinate women if they come to work without their panties. He demands kisses and tells women he wants to see them naked. We get complaints like this all the time. And he dragged one woman in a headlock while whispering in her ear. Bob is just quite the guy, isn't he? So let's evaluate this. The situations are related to employment. Bob's the head of the organization. All the victims are employees who are subordinate to him. The behavior is unwelcome to the women who receive this treatment. They never invited the behavior. They all find it offensive. They all want the behavior to stop. The behavior is severe, particularly with all the touching, and the extreme behavior that's involved is pervasive. Not only is it happening with one woman in the workplace, it's happened with several women in the workplace. And sometimes we find that in our harassment investigations, that one person has filed a complaint, but the alleged harasser has a history of bad behavior with other employees. And a lot of times those other employees have tried to get away from the alleged harasser. You know, they've gone to a different job at the employer, they've gone to a different shift, they've gone to a different building, or they've just, you know, completely quit the organization and gone someplace else. Because usually the first reaction of a victim is not to file a complaint, it's to get away from the alleged harasser. And then Bob's behavior is based on sex, so that's sexual harassment. And I would think a reasonable person would say it creates an intimidating, hostile, abusive work environment. Now, this is the case of ex-San Diego Mayor Bob Filner. And he ended up, at first when all this came out, he said he was going to stay in office, but he ended up being sentenced to 3 months of home confinement and 3 years of probation. He pled guilty to 1 felony and 2 misdemeanors for placing a woman in a headlock, kissing another, and grabbing a third. Now, we've provided some pretty extreme examples, but we receive complaints with far less serious allegations every day. A survey of human resource professionals said 86% of harassment complaints were due to verbal behavior. 43% said language, jokes, and teasing were the most prevalent forms of workplace sexual misconduct. And another survey said that emails and text messages were the most common method of sexual harassment. You know, during the Me Too movement, it shone a light on sexual harassment. But a lot of times when you read articles about the Me Too movement, the behavior was very severe, very egregious. But when I talk to human resource directors who receive complaints internally, a lot, and it's true in our complaints too, that a lot of times the allegations arise from just everyday conversations. People think they're kidding around, somebody makes an inappropriate joke or makes an inappropriate comment or gives somebody an inappropriate nickname, and then pretty soon we have some type of harassment complaint that's filed. So it's those common everyday interactions that can lead to a harassment complaint. I had our intake staff review the complaints that were filed with us for a 1-month period, and 90% involved some type of electronic communication or verbal communication. And the derogatory things that happened were like names, slurs, derogatory comments, spoken to in a demeaning manner, being mocked, teased, joked about, made fun of, either verbally or in some type of electronic communication. Only 10% actually had a physical component to it. So again, harassment doesn't have to be this egregious behavior. It can just arise from just everyday interactions. Now, we can only accept a complaint if it's based on a protected class. So when someone calls us and wants to file a complaint, they have to link it to a protected class, you know, their race, their age, their disability, something of that nature. But we receive thousands of contacts per year from people who feel like they've been mistreated in the workplace. So I wanted to share with you some of the comments that we receive about workplaces, you know, that there are rumors spread about them, that there's whispering, making demeaning comments about others, getting yelled at in the workplace, touching somebody else, getting called names like stupid or dumb or other inappropriate nicknames. We get a lot of contact about profanity in the workplace. We also get contacted about not keeping confidential information confidential, that maybe somebody has shared a family concern or a health concern with a coworker, and then they say that everybody in the workplace knows about it. We also get comments about, you know, invading people's personal space, standing too close to somebody, or, you know, reaching around them to get something off a shelf, or if you're like helping somebody with a computer, somebody reaching over them to get to the keyboard or show them something on the monitor. We also get calls about bullying, and bullying is when one individual or a group of individuals socially degrades the victim, either for the purpose of increasing their own self-comfort or for the enjoyment of others. So it shares a lot in common with harassment, but it's not based on a protected class. So someone's getting mistreated or joked about or teased, but it's not because of their race or their religion or their national origin or their age, something of that nature. We also, here's some other behaviors that violate respectful workplaces: sarcasm, eye rolling, tone of voice. We get a lot of people who say it's not what they said, it's how they said it, their tone of voice. Withholding information, publicly criticizing others. You know, we're supposed to praise in public and criticize in private. Not giving others an opportunity to fully participate in meetings or discussions, you know, purposely excluding them, interrupting them so that they can't complete their input or their discussion, whatever that is, ignoring people, baiting people, forgetting to include people. Now, if people who are persistently rude or uncivil, those people should be reported internally. You know, it's like a death of 1,000 paper cuts. You know, if you get one paper cut, it's not so bad. If you get 1,000 paper cuts, it's pretty bad. Now, the thing about these behaviors is that they become a stepping stone to a possible harassment complaint or harassment, and just in general. They become a gateway to even worse behavior. So I always use the kindergarten rule, that if we couldn't do it in kindergarten, then we probably shouldn't be doing it in the workplace. So are there any questions or comments? That pretty much concludes the presentation.
Thank you, Ruth. That was great. If I just wanted to reiterate, does anyone have any questions? I didn't see any in the chat box from earlier. Oh, someone's raising their hand.
Lisa.
Hi there. Do you have strategies for communicating, if you're a manager, with your staff related to specific things that you would like to see corrected without having to go to the Human Rights Commission?
Well, it's most people are going to try to deal with situations internally. And that's what we find a lot in our complaints, is that, you know, I'll give you an example. People who have been harassed, you know, they should file a complaint internally. So they put the employer on notice, and so that the employer can take action to look into the situation and address the situation, you know, do some type of corrective action so that it doesn't occur. So, you know, employers should be receptive to complaints and look into those complaints. You then if they conclude that some type of bad behavior has occurred, they don't necessarily have to conclude that it is harassment, like I said, but they can conclude that the behavior is unprofessional or inappropriate or crossed a social boundary, however you want to say it, and then take action based on that. Now, the action can be, it can be training for the alleged harasser. It can have them reviewing some type of anti-harassment policy and signing off on the policy again. Whatever the corrective action is should be in proportion to what the allegations were. So a lot of times we see that the employer can't necessarily substantiate that harassment had occurred, but they go ahead and take action like training or, having that person reread the harassment policy and sign off on that again. Or, if it is bad enough, some type of suspension or a suspension without pay or reprimand, or even going ahead and firing the alleged harasser. Now, a lot of times when individuals file complaints with us, the employer has taken some type of corrective action against the alleged harasser, and the victim, wants that harasser fired. They don't want to be in the workplace with the alleged harasser. And so we found that the employer has investigated and taken some type of corrective action. Now, if there's some type of corrective action like moving people to a different shift or to a different position, that action should be taken against the alleged harasser whenever possible, so that it doesn't look like the employer is retaliating against the victim. Now, sometimes the employers will ask the victim, well, do you want to shift to a different supervisor or go to a different shift? But you need to document that that's all voluntary for the victim. Is that answering your question?
Yeah, I think so. I just want to make sure that we have some tools for transit providers beyond just filing, but also what they can do to kind of nip situations in the bud early.
Yeah. Now, is this a situation where it's with coworkers, or is it a situation where it's with members of the public or customers are having bad interactions with the employees?
I think it's any of those.
Okay. And well, I know like in our situation, we do deal with members of the public, and sometimes members of the public, and maybe it's not possible for you guys to do this, but sometimes we have people who treat our staff unprofessionally. They're yelling, they're swearing, using profanity, different things like that. And sometimes we will limit their interactions to in writing only. They can, we want to serve the public. We're supposed to be here to serve the public. But that doesn't mean that our staff have to be treated to bad behavior. And so sometimes we will limit individuals to interacting with us only by email or in writing, not by talking to them over the phone. So I don't, that's probably kind of hard for you guys if you've got transit riders.
Yeah.
But still, you can have standards of conduct. And if people don't meet those standards of conduct, then they're not allowed to partake of your services. And we do get public accommodation complaints. And sometimes we see that in our public accommodation complaints that, somebody has filed a complaint saying they've been discriminated against by a provider. But then when that provider responds back to us, they're giving us this litany of bad behavior that this person was swearing at their employees or touched their employees or something of that nature. And so they terminated services with that person because of their bad behavior. But then it's important to document that so that you got that record.
Excellent. Thank you.
Any other questions? Well, I'm glad that we have such I noticed that we have people from Girard and Lawrence and Sedgwick County, Hoisington. So we've got people from all across Kansas. That's exciting. Ottawa. So I didn't realize that there was an organization that like served transit organizations all across the state. So that's pretty neat.
Yeah, thank you. I enjoyed this presentation, and maybe we can talk about doing something else another time. This was really helpful. Does anyone have any other questions for Ruth? Okay. Thank you so much, Ruth. We appreciate this. And I believe that is the end of our webinar. Thank you,
Okay, well,
everyone.
thank you so much. I appreciate your attention on time. I know that you're really busy, and so I know it's hard to take time out of all your obligations to spend an hour on a webinar. So thank you very much and have a great day.
Thank you.